Hey everybody, I want to make sure we talk about one more very important subject before we do our wrap-up video on criminal law basics. Now we're going to talk about justification of self-defense. Self-defense is one of those important things that everyone has to worry about. And so what we're going to do is we're going to get our Texas Penal Code, and I recommend you get one of these if the law is very important to you, regardless of whether or not you want to be a lawyer or you're just a conscious citizen and know your rights and know the law. You know, $20, $25, or you can get one that's a couple years old. They don't change that often. Get one that's off Amazon or something, and it's a good thing to have in your home library. It really is, and I recommend anyone get one for your state, of course. Now, here is the basic rules so far as Texas is concerned. Under Texas Penal Code 9.31, self-defense, the main part is it says except as provided in subsection B, and I'm going to get to that in a minute. Those are exceptions to the rule. A person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. The actor's belief that the force is immediately necessary is presumed to be reasonable if the actor, here's a couple examples, know or had reason to believe the person had entered with unlawful force into a building or habitation, a place of business. Um, Someone was removed or unlawfully removed from a habitation, a place. It was someone is committing some kind of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. Basically, those types of things, as well as um, not being provoked as well. So those are pretty much the good justifications. And those can translate into what we call stand your ground laws. Lots of controversial term, at least in states that are more conservative, southern states, Texas, Arizona. I don't want to say Florida because theirs is most controversial. There's something called stand your ground, which means basically, and a lot of people call it the castle doctrine, which means that you don't have to retreat um, past a certain point in a place of habitation. And that means maybe your car, your vehicle, whatever type of vehicle you have, or your home, a place of business, an office. You don't have to keep hiding in order to justifiably defend yourself and it not be considered assault or even murder. So that is one of the things that is very important. And most people, if you're like me, I'm a conscientious handgun owner. I'm always worried. Well, I like to keep a handgun in my residence in case something terrible should happen. I don't go looking for trouble, of course, but it's one of the things you must think about is if you have to protect yourself with deadly force. So this would be a good video for people who want to know what the law is, especially in Texas. So remember, the rules that it must constitute new or had reason to believe that the person who the actor has used force against uh, entered, unlawfully entered, and caused a reasonable fear that violence was necessary to stop the reasonable fear because it is immediate and necessary, and you had a reasonable belief that you removed or attempt to remove unlawfully with force the actor if someone is trying to drag you out from your um, your place of safety, and you can justifiably use force to prevent that from happening. As well as the big rule is it wasn't provoked. It was not provoked. So if you were to, I don't want to say start a fight, but if you were to um, try to get someone to assault you in order for you to kill them, that's almost that's kind of like laying a trap. That is not something that the court recognizes as legitimate self-defense. So don't do that. Of course, you'll probably still be charged with murder if you kind of set a trap and you bait someone into starting a fight or doing something bad so that you can kill them. That is no excuse. Um, and then, of course, you can use self-defense to prevent any kind of serious crimes, kidnapping, murder, sexual assault, robbery, or any aggravated version of those. So just remember those. Now, here's when they don't count. This is the important stuff when it says subject to the exceptions in B. Uh, it's not justified in response to verbal provocation alone. That means you can never use violence against someone with force based on verbal threats, verbal provocation. There must be some manifest form of immediate danger. That's B1. B2, to resist an arrest. No matter if you think that the arrest is unlawful, and it may be, if someone is arresting you and you are certain that it's unconstitutional or that your rights have been violated, you cannot use violence against a police officer. Naturally, that's a bad idea anyways, because they have mace and guns and tasers, and they will hurt you very badly if you try to resist an arrest. Go ahead and sue after the fact when you get your attorney. Um, so, uh, if you consented to the force. Another a great example is, hey, I want you to take your best shot at me. Come on, I know, you know how tough I am. Come on, take your best shot. That you cannot justify using force of self-defense when you consented to whatever the action was. And then, of course, if the actor provoked, remember what I said about the, sort of laying a trap. It doesn't mean that if you get into an argument and then it turns into a fight, you can't protect yourself. No, you can protect yourself if you start some kind of an argument and it has an unforeseen fight. Um, However, um, there is a exception to that. If you were to start a fight, but you abandon the fight and you communicate, no, I don't want to do this anymore, I don't want to do this, and then they start to fight back, still, then you can call it self-defense. But lawyers are smart. They'll know based on the facts whether or not you were probably trying to bait that fight and trying to use self-defense as a justification. So just remember that. And that's 4A and B. So just remember, even if you start the fight and you say, no, I don't want to do this, I don't want to do this, I want to stop, and they continue, then you can still say that you used force as self-defense. Now, last I'm going to talk about 9.32, which is deadly force. And it's a very long one, but just remember that this is important in the sense that deadly force is obviously the greatest amount of force you can use, so it has the highest burden. Anytime you want to use deadly force, a handgun, a knife, any kind of weapon to defend yourself, the force that you have to be protecting yourself or another from should be something that only deadly force can stop. And this is considered the same in both tort law and in criminal law, that it must be equal and not, this great exaggeration of force, that if the person is down on the ground after you knocked him out, it took a good swing, and that you go ahead and grab your gun and put two more in his eyeballs, that's probably not deadly force. Probably wasn't needed at that point because the threat had stopped. So, and of course, those are important things to check with your state. But in Texas, make sure that you read 9.32 because this is deadly force defense of a person. Now, it must be based on the things in 931, so that means that you must look back to regular use of force in self-defense, as well as when and to the degree the actor reasonably believes deadly force is immediately necessary. That's 9.32A2. That means that only you must think that deadly force is necessary to stop the fight. Perhaps that person has a point to create a deadly situation against you or someone else. So that is, if you reasonably believe that it's justified that using deadly force is the only way to stop that, then there is a justification there, and it can be had. But it's one of those things that needs to be pretty legitimate. Remember, in the case of these types of criminal cases, the court must prove that you did not use self-defense. So this is a good thing for you, the citizen, that you would say the state itself has to prove that you were not defending yourself and that you murdered that person outright. And so at least you have a little bit of that help of belief on your side that it is not. You don't have to prove self-defense. They have to prove it wasn't self-defense in order to prosecute you as part of having actus reus mens rea and proximate cause for a major murder or for resulting in death crime. So just remember that. And then obviously you can use it to prevent aggravated kidnapping, murder, sexual assault, aggravated sexual assault, aggravated robbery, or regular robbery. So remember that your belief has to be reasonable, and that's both a subjective and objective standard. That your belief that deadly force is reasonable must be something that a regular person put in the same situation, what we call that ordinary general person, would also think this guy needs to. That the only way to stop this guy, he's crazy, is you need to kill him. Otherwise he's not going to stop. Those kinds of things, and you have to share the same. Otherwise, the court's just going to look at you and say, "Well, most people wouldn't think you needed to kill a person because he pulled out, a butter knife on you." Most people would say you obviously could make if you had to defend yourself with a handgun to shoot the ground or shoot a warning shot or shoot his foot versus shooting him straight between the eyes for having a butter knife. So there are reasonable justifications for having to use deadly force under TPC 9.32. So just remember that, especially when it comes to handgun folks, that people that were really into carrying handguns, you have your CHL or your um, concealed handgun license or your concealed carry CCW in several other states. So just remember that, and you should always, especially if you feel like you have to use deadly force, have the phone number for attorneys and make sure that you cooperate with the law enforcement and always be truthful in what happened in those types of cases. And while I'm not trying to give anyone any specific legal advice, this is just common knowledge that in those cases, self-defense is always going to be something that you must prove all of those. The state must prove that those elements weren't there, and if they can, you can go down for whatever criminal act you did, whether it was assault, aggravated assault. So those are just those types of things. So just remember, in the case of self-defense, that you reasonably believe that the force is immediately necessary, up to and including deadly force, to stop the threat of unlawful force, or someone using unlawful force against you. What does that mean? Unlawful force of trying to enter your space, trying to trying to harm you, cause immediate harm, trying to remove you from your place. So that is, and it must be equal to the type of threat. So there is a level that it can be, up to, but not beyond. Otherwise, you can have excessive force. And so those are important to look at in your state. So I appreciate you watching. We're going to do one more wrap-up video on sort of the elements of criminal law, but I appreciate your time if you watched all these videos, and hope you're doing well.